Welcome to our video series on types of trusts and how they work. Today we're going to be addressing a single individual's estate and what takes place when they pass, whether that person has a will in place or a living trust, and show the potential gain or loss to the estate. First, I think it's appropriate to discuss what happens if a person has done no estate planning at all. They don't even have a simple will. Well, if they don't have a written will in place, their estate has one for them. This is called dying intestate, which simply means you have no documents in place that discuss the distribution of your assets. That being said, their estate has a will for them, although far more complex and not written to their desires. The courts will now determine who owns the assets, and this process can cost the estate dearly. A better option is to at least have a will in place. Unfortunately, all wills are destined for probate. Probate is the dreadful court process that determines title to assets. For example, your mom passes away and you and your siblings are ready to sell her home. If the home is titled in her name, the courts will now determine title, or who should own that property, and it could open the door for contention among the family, even if the will stipulates who should receive the assets from the sale. Probate is not only time-consuming in public, but can cost the gross estate in upwards of 8% with legal and administrative fees. So what's the best solution? The best solution could be a revocable living trust, which gives the individual a number of benefits, the greatest of which is control. A single individual can plan with a single A trust. If that trust is fully funded, there would be no probate and no cost of probate to the estate. But what is fully funded? Fully funded just means all the individual's assets are in the name of the trust. For example, the deed to the home has the trust name and not an individual's name. Bank accounts are in the name of the trust and not the name of the individual. You get my point. The only assets that should not be in the name of the trust are qualified plans, which means IRAs, KEOs, a qualified annuity, or a 401k plan. Changing title on these assets is categorized as a lump sum distribution to your beneficiaries and will be taxed appropriately. There are other ways to plan for these assets, and we get into details in subsequent videos. But going back to the single A trust, let's take a look at a comparison of a $500,000 estate with a will versus a living trust. We will assume a $1 million federal state tax exclusion for 2013. With a will and a trust, a $500,000 estate would not be subject to federal estate taxes. However, the will would be subject to probate. Using an average cost of 8%, this estate would pay $40,000 to the probate lawyers in courts to determine title to the assets. In contrast, the trust avoids probate, and the heirs do not lose the $40,000. The living trust itself affords an individual the right to say who will manage their estate once they pass, who will receive their assets, and how those assets will be distributed. The trust protects the individual's privacy and preserves their estate. They also have the right to change the document at any time while living, and most importantly, they pass assets to their family quickly and efficiently without courts. Trust planning addresses a number of different concerns, including some taxes, supporting a disabled child, or children with money management problems. The options can be endless. The critical components to our living trust documents versus others is that we include over 200 provisions that address the general terms of the trust, trust property, trustees and successor trustees and their powers, allocation and distribution of assets, and so much more. This document has continued to grow and is a result of more than 25 years of practical application. Does this mean that the trust is too complex for a simple estate? The answer is no. The number of provisions don't equal complexity, they equal protection. It is also imperative that a single individual have the necessary ancillary documents in place. This means a power of attorney for assets, power of attorney for health care or a health care directive, living will, and a nomination of conservator. Our trust package includes these essential documents. And for more details on ancillary documents, check out our video, How Do I Protect Myself While Living?, where we address the power these essential documents hold. In summary, like most people, a single individual wants to preserve as much of their estate as possible for their heirs without having it diminished by extensive legal fees. They want to retain control over their affairs, and they want to pass their assets how they see fit. They want their private business to remain private. The Single A Trust provides this peace of mind, knowing they have the right documents to protect themselves and their family from unnecessary financial drain.